I'm just going to set my timer here. Okay, so the title of my written presentation is Know Your Rights and Freedoms the Toronto Police are just going to violate anyways, if not hurt you, for exercising them. Before I speak about one's right to the security of the person, I first want to address the right to remain silent and how, in dealing with the cop who will try to create joinder with you before they arrest you tomorrow at Yonge Dundas Square for protesting, as an example, that Scott Duncan says it is better to simply tell them, I'm not authorized to answer questions, and just to let you know to your heart, I have a question for Chief Rader at the end. So this is from R versus Latimer, Court of Appeal for Saskatchewan from 1995. Mr. Justice Corey made the point in R versus Story, 1990, Supreme Court of Canada, that the requirement that reasonable grounds must exist to justify an arrest without warrant is there to safeguard the liberty of citizens who might otherwise fall prey to the abuses and excesses of a police state, which we've had here in Toronto down at Yonge Dundas Square the past 2 Saturdays. It also mentions Section 7 of the Charter. Everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. Now, in the Interpretation Act of Canada, security is defined as security means sufficient security. It's also grouped together. They're not separate. They've been grouped together with the definition for sureties, which is sureties means sufficient sureties. And when those words are used, one person is sufficient, therefore, unless otherwise expressly required. And the French definition given for security and sureties is caution ou cautionnement. I want to point out a maxim of law that says coupling words together shows that they ought to be understood in the same sense. As an example, I provide the YouTube link here where the then Toronto Police Chief Mark Saunders nods his head seemingly in agreement when I remind former Councillor Chin Lee at a past meeting that the Crown is the surety for the person Mr. Derek Moran I have. This is from Citadel Assurance versus Johns Manville, Canada, 1983, Supreme Court of Canada, said that the compensated surety cannot escape the liability found in the bond merely because of a minor variation in the guaranteed contract or because of a trivial failure to meet the bond's conditions. In other words, courts have adopted the strictissimi juris construction of the surety contract. Now, strictissimi juris is defined in Black's Law Dictionary as of the strictest right or law to be interpreted in the strictest manner. This term was usually applied to certain statutes, especially those imposing penalties or restraining natural liberties. Now, in all these videos put out by the Rebel of what's been happening down at Yonge Dundas Square, I've noticed a recurring theme where the officers keep telling people that, I'm giving you a caution. Well, in Black's Law Dictionary, caution is defined as security given to ensure performance of some obligation, the person who gives a security. So if these officers keep telling people that, I'm giving you a caution, and the legal definition for caution is the person who gives the security is security given to ensure the performance of some obligation, then my question for Chief Rader is, when one of these Yonge Dundas Square officers tells someone in these videos put online by the Rebel, I'm giving you a caution, is that officer telling them in a roundabout way that the officer will be acting as their surety once the matter goes to court? And I'm just going to check my time here. I got about 50 seconds. I just want to point out in Mercer versus Attorney General for Ontario, 1881, the Supreme Court of Canada pointed out the royal prerogatives, which in England are not the personal appanage of the sovereign, but are the property of the people, in which the sovereign holds in trust to exercise them in the interests of the British nation, are equally exercised in the provinces by the Queen, not more, however, to her personal profit than in the mother country, but for the people of the provinces, with respect to whom these prerogatives have not lost their character of a trust, and that not being able to exercise them herself, she has delegated their exercise to the lieutenant governors, who are her mandataries. So the royal prerogatives, I guess that makes us all royalty, are really belong to us, property of ours, which are held in trust by the sovereign. And my time's up.
Thank you, Derek. Chief, would you like to comment on Yonge Dundas Square?
Especially the surety question.
What I will say, Chair, is that the pandemic is both a significant public health crisis and a public safety issue. And I'm proud of the work our members who throughout the pandemic have operated with professionalism and exercised compassion and significant discretion. I'm also proud of our communities who have also, to a large extent, acted responsibly. However, we do have a small, organized, confrontational group in particular that we will continue to address proportionally. We have a provincial emergency order in place, and it is our duty to enforce the law.
Thanks, Chief. Board members, any questions of Derek?
So, Chair Hart, that wasn't my question. That didn't answer my question, though. Should I repeat the question?
No, that's okay, Derek. I know you wanted a definition answer, but the Chief gave you the answer that he gave you.
Well, the question was about surety, so you completely passed over that.
Yeah, maybe for good reason, Derek. Okay. Board members, any questions?
I'm sure.
Seeing none. Thank you, Derek. Dubie, can you put on the next deputy, please?
Yes, Chair.